let me first, therefore, take it to Anjali Gopalan. Anjali, as someone who's been fighting for this, a petitioner, what is your first reaction to the Supreme Court verdict? Is it a blow, or do you see some positives in the judgment that came today?
Look, it's really disappointing, at least for me. It's terribly disappointing. Not only did this not get accepted, but you didn't even have any kind of rights given to the community. So overall, very disappointing, and I think a very big blow to the movement. Do I see any positives? Well, couple of positives. I think the two things that I would say are positive is that at least the court has expanded the definition of discrimination. So, and they have very clearly told the government as well as the police how they need to conduct themselves. So that was a good thing. The other good thing that happened was around the transgender issue, where the courts were very clear that, look, transgender people can marry other transgenders or cisgender people, which means, for example, a trans woman can marry a heterosexual man, or a trans man can marry a heterosexual woman, which means then they get all the benefits that people in a married relationship get. So these are the two things, I think, that came out of the judgment today. But otherwise, it was very disappointing. Not only that, this complete wiping out of this whole issue of adoption. There are so many children lying around in adoption agencies without a good home. So completely to deny the community adoption. Not only that, couples in our country cannot adopt. Couples who are living in a live-in relationship cannot adopt children, whereas single people can. So, I mean, you are denying this right to so many children just lying around without a good home. So, yeah, it's been very disappointing, I think, overall.
How do you see, Mahesh Jethmalani, this 5-judge bench? You're both a member of parliament as well as a Supreme Court senior advocate. Do you see it as a conservative judgment reflecting in a sense that the court has been extremely cautious? Or do you believe the court has simply gone by separation of powers and says, this is all that we can do under existing laws, it's for parliament to enact it, and therefore it's a legally, politically correct judgment, but nevertheless a conservative one?
I see it as a judgment according to law, because the judgment does not either repel or accept that there's a right to marry. Right? It says there's no constitutional right to marry. The right to marry is not a fundamental right arising out of the Constitution. That's what all 5 judges have said. Right? 2 of them have said that the right to a civil union, right, is a constitutional right. But the majority judgment has said not even the right to a civil union is a constitutional right. Now, in that event, right, what the court has said, what the court means is that, look, if this was a constitutional issue, if this right flowed from the Constitution, then we could give relief to the LGBTQ community. But since it doesn't flow from the Constitution in our view, right, then this can only be conferred. The right to marry, same-sex marriage, can only be conferred by statute. And for that, it is Parliament and the government which will have to introduce legislation in order to bring in the right to marry for people belonging to same sex.
You know, in a sense, what you're saying is because the court's original premise was that the right to marry is not a fundamental right, from that, in a sense, the rest of the judgment flows, or at least the majority judgment. Anand Grover, did the court get it wrong? Did the majority judgment, by denying a constitutional right to marry, in a way, wasn't willing to go far enough?
Well, I think the court has got it wrong. I don't think we made enough of grounds in terms of our argument to convince the court. And I think a future court can be convinced. See, the courts have interpreted the Constitution very liberally. For example, under Article 21, there's no explicit right to dignity, privacy, etc. The courts have interpreted that. Now, just take a layman's example. Suppose tomorrow Parliament was to say that we are actually forbidding anybody to marry. Just imagine that. What would a lawyer do? He would or she would go to court and say, no, there's a fundamental right to marry. And would the court deny that? A converse of what has happened would obviously make it amply clear that there is in fact a fundamental right to marry, and that also flows from international law, which we are bound by.
No, where does this fundamental right to marry flow from our constitution? How does it flow from our constitution?
So let me explain that. As I said, they are not explicit rights. They are interpreted by the court. So under Article 19 and 21, we can say there is a right to intimate association, a fundamental right from which it flows. So it's an interpretive exercise. A large number of rights have been interpreted and read into the constitution by the courts. And they could have done it, but they haven't done it. That's what happened in the US and the right to marry. The other disappointing thing is that, please understand, what is happening? There is discrimination against non-heterosexual couples. What is happening after Navtej Johar? They were told very clearly that you can have sex, consensual, in private. There's nothing wrong with it. Now, the next step is that why can't a non-heterosexual couple marry like anybody else? So if you tell them you can't marry, you're treating them as second-class citizens. It's so clearly, manifestly evident. So there is discrimination, and therefore the court should have stepped in and said, no, there is a fundamental right.
So you're saying it falls foul of right to equality. You're saying it falls foul effectively of the right to equality and the right to live with dignity. Am I correct?
Yeah, dignity and intimate association.
Okay.
That the court has accepted. My argument, which I posited before the court, Justice Chandrachud has accepted the right, fundamental right to intimate association, privacy, dignity, equality, and right to intimate association. But you are right that they have said no fundamental right, and everything flows from that. That's the correct logic in the judgment.